record to the cloud. So before we get into the content of today's training, we'd like to make a couple acknowledgements. The first is to the Michigan State Housing Development Authority. It is because of a generous grant from MISTA that we are able to offer these and other trainings free of charge. It's important to note as well that we are not attorneys here at the Fair Housing Center of Southwest Michigan. Today's information is for educational purposes only, and it is not legal advice. I will be talking about some court cases, but I am not qualified to give legal advice, so nothing offered today is legal advice. This presentation is being recorded as part of the grant, and I'm now going to talk a little bit about the Fair Housing Center of Southwest Michigan. So the Fair Housing Center of Southwest Michigan serves Allegan, Berry, Berrien, Branch, Calhoun, Cass, Kalamazoo, St. Joseph, and Van Buren counties. The Fair Housing Center of Southwest Michigan, we work to promote integration and to eliminate housing discrimination. And we use three tools for this. We use education, advocacy, and enforcement, and that ordering is intentional. The Office of Housing and Urban Development, or HUD, estimates that there are 4 million occurrences of housing discrimination each year. Of those, only about 11,000 go reported. So the idea is that if we educate well enough, we can ideally eliminate housing discrimination before it even occurs. We can also use education to help people we can also use education to help people to recognize and encourage them to report housing discrimination when it happens to them. And after that, we can advocate on their behalf, and we can work to secure justice through enforcement of the Fair Housing Law. And finally, we can learn through our efforts and successes in enforcement how best to direct our further educational programs to maximize the effect of those programs. Pardon me. Oh, I wanted to take a brief moment here. Because we are in a webinar, if we have any questions, please add them to the question and answer box. I've got some time at the end open for answering those questions, and we'll get to them after the presentation. So what is fair housing? Broadly, fair housing is the right to equitable access to housing and all services involved in the housing transaction. So that includes, but isn't limited to, renting an apartment, buying or selling a home, having that home appraised, purchasing insurance for the home, refinancing, et cetera, et cetera. Anything that involves that housing transaction, fair housing does apply. So the goal of this session is to give you information that can help you protect yourself and the members of your communities. And this training is largely designed around the tenant's perspective. However, landlords and housing providers are expected to know these rules and their related responsibilities. So if that applies to you, please pay attention. And remember, you don't need to memorize everything today or walk away as a fair housing expert. You can always call us at the Fair Housing Center, and we will be happy to answer any questions. So, fair housing is the right to equitable access to housing. What that also means, or another way to say that, is that fair housing is the right to pursue housing free from discrimination. So what constitutes fair housing discrimination? There is a formula for determining whether a situation constitutes housing discrimination, and it consists of 3 elements. Those elements are a covered dwelling. This is very nearly all residential constructions are covered by fair housing. Get to that in just a moment. A protected person. Federally, there are 7 protected classes. That's race, color, religion, national origin, sexual orientation, and gender identity. I'm sorry, that is now no longer a federal protection. That is now just a state protection in Michigan. Family status and disability status. Now, state and local governments can add to, but never remove from these protections. And each of these protections were won over time. And we'll cover that timeline in a little more depth here very soon. And finally, an unlawful practice needs to be occurring, and that is any practice that treats differently any member of a protected class during any part of the housing transaction. It doesn't need to have been an intentional action, and that too, you may be able to guess, we'll cover in more detail here shortly. So, a covered dwelling is the first element, and a dwelling is more or less a different word for housing. So you can see here that houses, condominiums, apartments, shelters for the unhoused, college dorms, even things that aren't necessarily a building, such as a homeowners association or a public housing authority. These are all covered by fair housing. So yeah, dwelling should be construed as having as broad a definition as possible. There are some exceptions, but all places a person could make their residence are covered by the fair housing. So hotels, motels, Airbnbs, and things like that, they are typically not covered by fair housing. And the reason for that has largely to do with the idea of a primary residence. If someone is staying in a hotel, for instance, usually they've got a primary residence. They can go home to somewhere. And so fair housing would not apply to their stay in that hotel. In a situation where a person does not have a different primary residence, however, fair housing law would apply. And so I mentioned there are a couple of exceptions. Some exempt housing, religious organization exemptions are going to be an important part of today's presentation, so I'm just going to kind of gloss over that. But basically, religious organizations are allowed to give preference to people of the same religion if the housing that they operate is operated non-commercially. So let's say a Catholic organization owns a bunch of apartments and they want to give those leases to other members of the Catholic Church. They can do that so long as it's not being operated for profit. There's also the Mrs. Murphy rule, or owner-occupied housing or smallholder housing. So what this is it exempts smallholding housing owners from the fair housing laws, and that triggers in one of two ways. Either the owner lives in a building, federally, the building has to have 4 or fewer units that the owner or a member of the owner's immediate family lives in, or as long as they're selling a house without the use of a brokerage firm, and whether if they own, I believe in Michigan, it's 3 or fewer properties, those properties are not subject to fair housing. Finally, there's senior designated housing or housing that is covered under the Housing for Older Persons Act. Now, this is exempt federally only from familial status protections, and it's separated into 2 categories. There's housing for persons 55 years old or older, and for persons 62 years old or older. Now, in 55-year and older housing, there's what's known as the 80-20 rule. In 80% of units must be occupied by at least one resident at least 55 years of age to count as senior designated housing and to be exempt from familial status protection. There is also housing for 62 years old and older, wherein 100% of units must be occupied by a resident of that age. In both cases, usually there will be a further allowance for disabled people of any age to live in the housing. And finally, further allowances exist for live-in staff, such as caretakers or employees of the building, can live there regardless of their age. I know I've mentioned familial status. I've mentioned these protected classes just a little bit. So what are they? Federally, again, there are 7 protected classes, and here they are presented in teal or on the left side. No state can limit these protections, but we can add to them. So here in Michigan, the additional protected classes that apply most to housing are age and marital status. And I say most because the controlling Michigan civil rights laws that add these protections list more than just age and marital status as protected classes. But those extra protections apply usually to employment cases instead of housing. This is somewhat common, especially in the state as opposed to the federal level, where employment is protected before housing. And finally, in late 2024, Michigan added source of income protections as part of its civil rights package. So when we say race, we mean all races. Color refers to the color of one's skin. So a darker skinned person of Indian origin has the same rights as one with lighter skin. Religion includes one's membership or lack thereof in an organized religious group, as well as one's spiritual ideas or beliefs. And that is, again, the focus of today's presentation. So we'll get to that in great detail here in a little bit. We also have national origin. This is the country where a person was born or from where one's ancestors come. Here in Michigan, we still have protections for all sexual orientations and gender identities, and that pertains to one's actual or perceived sexual orientation, as well as the identity, expression, or perception thereof. Family status refers to the presence of one or more children under the age of 18 living in the household in a custodial relationship with an adult. So that's a parent, step parent, an adoptive parent, guardian, foster parent, someone who is pregnant or is in the process of becoming pregnant or acquiring legal custody of a child. These things can't be used against you in a discriminatory fashion. Disability is the most cited protected class in fair housing complaints. And that disability refers to having, being perceived as having, or having a history of having an impairment that limits one or more daily life activities. We have a training on disability. We offer them every grant cycle. And if you're interested in that, let me know after the training, and I will be sure to put you on a list for that. Marital status refers to someone single, married, separated, engaged, widowed, divorced, and in some jurisdictions simply cohabitating rather. Age, individuals of any age, and source of income means that a person seeking housing cannot be turned away if part of their income comes from say SSI, housing choice vouchers, veterans benefits, any sort of legally derived non-employment income can't be used as a source of discrimination. And as I said, all these classes are protected by specific laws. So we'll look now at a timeline of those laws. The protections afforded by fair housing were won over time. And the timeline that you see here is by no means comprehensive. It's just a snapshot of these moments where protected classes with respect to housing were enshrined into law. But first and foremost, after the end of the Civil War, was the ratification of Amendments 13 and 14. These amendments gave citizenship to the newly freed slaves and native-born Black Americans. And the Civil Rights Act of 1866 details primarily the economic and property rights of these new citizens, including explicit protections against abridging those rights on the basis of race or color. And so this is the first instance of a protected class in the United States. Later in the mid-20th century, President Lyndon Baines Johnson was compelled to sign the Civil Rights Act of 1968. Organizations such as the NAACP and the GI Forum, which is a largely Hispanic veterans families service, as well as the advocacy of Martin Luther King Jr., were instrumental in adding national origin and religion protections to the Civil Rights Act of 1968. The Fair Housing Act, Title 8 of the Civil Rights Act of 1968 is where these housing protections are laid out, and Title 8, therefore, is the Fair Housing Act. And that Fair Housing Act would be amended further first in 1974 to add sex as a protected characteristic, and then again in 1988 to add disability and family status. Alongside the federal fair housing laws, state and local governments have passed their own fair housing laws. Here in Michigan, ours is the Elliott-Larsen Civil Rights Act, first passed in 1975. And the ELCRA, or Elliott-Larsen Civil Rights Act, was amended in 2023 to mirror a Biden administration executive order, and that expands the protections for sex to include all sexual orientations and gender identities. And last but not least, on December 30th, 2024, Michigan Governor Gretchen Whitmer signed into law a bill package that included Senate Bill 205 of the 102nd Legislature, and that added fair housing protections based on source of income. A little bit more on source of income here. So when we have source of income protections, what that means is that a landlord cannot discriminate if a tenant's income includes Section 8 housing choice vouchers, public assistance, veterans benefits, Social Security, supplemental security income, or other benefits. Just so long as this income is legally derived, it must be counted as real income. There are some further recent changes that affect fair housing. One of the more important is, as I've mentioned, as of January 20th, 2025, we've rolled back protections at the federal level on sex. They no longer include all sexual orientations and gender identities simply one's biological sex. Michigan law still protects the broader population. Disparate impact is another recent change. We'll get to this on the next slide, what disparate impact means legally, but it's no longer a valid angle for investigating claims of discrimination at the federal level. And as these changes occur, we'll work to provide information and bring that to you. So, disparate impact, as I mentioned, is one of the forms of discrimination. And only behavior that involves one or more protected class is illegal under the Fair Housing Act. So, for example, let's say a Michigan landlord refuses to rent an apartment to a prospective tenant. In that refusal, which would be an unlawful practice, refusal to rent, in that refusal itself, that landlord has not violated the act. Again, it's a covered practice and a covered property, but if it can be shown that the landlord's action was based on a protected class, once again, federally, race, color, religion, national origin, sex or gender, disability, family status, and disability status, if that can be shown, then we may have discrimination. If the landlord's action was based on any other factor, for instance, the prospect's bad credit, no violation of the act has occurred. Now, the landlord in this example does not need to have done anything on purpose or otherwise with discriminatory intent. The practice is prohibited even if it has a disparate impact, and again, only true now at the state level. So a practice that appears neutral, or what's known as facially neutral, can have a disparate impact because of how protected classes intersect with reality. So I like to use the following hypothetical to kind of illustrate that. So let's say that a property developer wants to build affordable housing in an area specifically intended for occupation by nurses. Career is not a protected class, and so you're not immediately in trouble there. And the move could even be considered noble given the profession of nursing. But in the developer's area, 95% of nurses are white. So by attempting to limit access to the dwelling only to the area's nurses, the developer has unintentionally limited access based on race. And this creates a disparate impact. And remember, the disparate impact angle of analysis is now only valid at the state level. Federally, it is presently seen as an attempt to cloak or sneak in diversity, equity, and inclusion practices that are outside of this administration's scope. Retaliation is the third type of discrimination, and this is always out of bounds. So even when a complaint does not constitute an example of illegal housing discrimination, retaliating against the person who raised that concern is now illegal under the Fair Housing Act. And finally, failure to accommodate is neglecting to allow reasonable accommodations or modifications. This largely has to do with, you see this often in cases of disability, but you can also see it, especially in employment law, with things like ruling back certain policies about religious expression. But failure to accommodate is the final form of discrimination. However, we're going to now turn to our main topic today. So religion and fair housing. While other protected classes such as disability or race persist as the most commonly cited protected classes in fair housing complaints, religion is not seen that often as a percentage point in fair housing complaints, but it does occupy an interesting position with respect to fair housing. Religion is both a protected class and an exemption class. So while your rights cannot be abridged because of your religion, your rights can sometimes be abridged based on your religion in certain very proscribed cases. And we'll discuss now in turn, religion is a protected class, what religious discrimination can and has looked like in housing, and finally, where the religious exemption comes from. Throughout that line, we'll be looking at certain related court cases as well as news stories in order to kind of pull those examples. So religion as a protected class comes from the Civil Rights Act of 1964. And so the Civil Rights Act of 1964 was the first bill to introduce religion as a protected class in the familiar sense. Religion has been a protected aspect of U.S. citizen, excuse me, it has been a protected uh, aspect of U.S. citizen identity since the passage of the First Amendment. That was in 1791. So that fundamental freedom to and from religious expression is the source of religion's curious interaction with the Fair Housing Act. And we're going to look briefly now at a handful of cases that deal with a somewhat persistent issue in that intersection of religious rights and fair housing rights. So the five cases here: Swanner v. Anchorage Equal Rights Commission in Alaska, Mr. v. ARK in Illinois, the Attorney General v. Desolets in Massachusetts, McCready v. Hoffius in Michigan, and Minnesota v. French in Minnesota. These don't concern religion-based housing discrimination from the tenant side. They do, however, each centrally concern the religious rights of a landlord and whether those rights supersede those of tenants. So in each of these cases, an unmarried couple is attempting to rent an apartment from a housing provider who believes that renting to unmarried couples would facilitate premarital relations. And that goes against their sincere expression of their religious beliefs. While these cases have gone through through their assorted states, district, appellate, and in some cases Supreme Courts to different outcomes, they all do have in common the question of whether fair housing rights can be abridged, for religious reasons. Uh, so it's not, of course, this curiously persistent style of religious case in housing. That's not the only way that one's right to fair housing can clash with religion. And so we'll look at some examples now of what religious housing discrimination can look like. So the examples here on the slide are all pulled from guidance published over the years by governing authorities that deal with fair housing. While these are written as general hypotheticals, of course, they do have a historical basis. So refusing to rent, I'm so sorry, my nose is itchy. Refusing to rent to a woman who wears hijab or another head covering would be pretty self-evident religious housing discrimination. Allowing Christian tenants to display Christmas or Easter decorations, but disallowing decorations related to holidays of other faiths, that's clearly discriminatory toward those other faiths. Discouraging a religious housing seeker from a neighborhood because it does not have the related place of worship. This is what's known as steering with a religious bent, and steering is illegal under the Fair Housing Act. And then finally, prohibiting the use of a community room for religious purposes, but allowing the use of that same community room for secular purposes, or promoting secular use of the community rooms while completely neglecting to mention that the community room could be used for religious purposes. That would create a disparate impact. Now, as I mentioned, or you've probably gathered, this is not the only thing that religious housing discrimination looks like. It doesn't come in these four flavors. It comes in a number of different ones. And in order to take a better look at that, we're going to go to a case, Morris v. West Hayden Estates, that deals primarily with holiday decorations. So Jeremy and Christy Morris, their house is pictured here. Jeremy and Christy Morris entered a contract with West Hayden Estates First Edition Homeowners Association, and I'll just be calling it the HOA from here on out, for the purchase of a home in the relevant subdivision. And shortly after entering the contract with the HOA, but prior to the purchase of the home from the sellers, the Morrises informed the HOA about both their intent to buy the home, as well as to host at that home their annual Christmas fundraising event. Jeremy and Christy Morris are enthusiastic Christians. The HOA responded back in January of 2015 that fundraiser may, in the belief of the HOA and the board members thereof, violate certain provisions of what's called the CCR, the Covenants, Conditions, and Restrictions clauses. for the West Hayden HOA. The Morrises were also informed that some members of the subdivision were not Christian and that they were concerned that the Christmas fundraiser may cause issues with those residents. The HOA then subsequently informed those other residents of the Morrises' plan for the Christmas fundraiser. So the Christmas fundraiser was quite a large to-do. This pull quote is from an article entitled "Whose Holiday Is It Anyway?" published by a Tempe, Arizona-based law firm, CHDB. And you'll notice in this pull-away quote that about 20,000 lights, live nativity scenes, actors, live camels. It was a very large production. And so the Morrises purchased the home in March of 2015. And in October 2015, when they gathered an understanding of how large this fundraising event would be, the HOA made the call that they were going to disallow the Morrises from holding this fundraiser and informed the Morrises that moving forward with the Christmas fundraiser would result in legal action from the HOA. Now, the Morrises held their first fundraiser in the year of 2015, and the HOA ultimately capitulated on that legal threat. But since then, the Morrises allege that from the first fundraiser on, the HOA waged a war of harassment against them by encouraging members of the HOA to engage in harassing behaviors such as threatening the Morrises on the street, threatening them on Facebook, interfering with the Christmas fundraiser. The Morrises also allege at certain points in the court history a number of death threats being made to them by members of the HOA. This obviously would cause them a great deal of distress. And so the Morrises decided to sue the HOA. And in their eventual lawsuit against the HOA, they brought 4 legal claims, one of which was under the Idaho State Human Rights Law, which is not relevant to our discussion right now, and 3 under the Fair Housing Act. And we're going to take a look at those claims. These claims are made under 42 U.S. Code Section 3604, B and C, as well as 3617. 42 U.S. Code is, 42 U.S. Code Section 3604, and those things coming after are how the Fair Housing Act is described in the U.S. Code. So, pardon the notation. But looking first at the disparate treatment claim under 3604B, the Morrises needed to show that, quote, an invidious discriminatory purpose was a motivating factor, end quote, behind the actions of the HOA. Under 3604C, which is the prohibition of published materials indicating a housing preference against individuals of a protected class, the strength of their claim under C rests on an assertion that the HOA sent a certified letter to residents indicating a preference against Christians. Now, while the HOA did send a letter to residents informing them of the Christmas fundraiser, this particular subsection applies to publications related to sale or rental of the real property. So the certified letter sent to residents in the area isn't related to the sale or rental, it's related to like neighbor behavior. And so it's not, it doesn't fall under the auspices of 3604C. And finally, the HOA was alleged to have interfered with the Morris purchase because of their religion by attempting to dissuade the sellers from interacting with the Morrises. Now, this claim the courts have found has some purchase to it, and the purchase of a home is a protected activity, religion is a protected class, and the HOA did interfere by discussing with the sellers the Morrises' plan. Now, you'll see at the top that a jury did award the Morrises $75,000 in damages at the start of their lawsuit, and that has moved up through the courts, and the decisions have varied in those upper courts. So what we have then from these takeaways is we get a picture of how a homeowners association can handle assertions of religious expression. So if we want to look at these following hypothetical policies, let's say an HOA has a policy that says accepted holidays for the purpose of displaying decorations are limited to Christmas, Hanukkah, and Kwanzaa. That, I think, is clear to see is right out It's very obviously discriminating against religions that are unrelated to those listed holidays. The second policy, no holiday decorations shall be displayed by residents whatsoever. That's an undue suppression of religious expression. You're getting into, I think you could easily make the case that it's discriminatory intent against religious expression, disparate impact, et cetera, et cetera. Now, the third policy, the association welcomes residents to display holiday decorations for any holiday. Make yourselves at home. That's just fine. And the reason for that is it allows the HOA to treat individuals based on their behavior, not their characteristics. If the holiday decorations are causing a problem, the HOA can add a nuisance or hazard clause that would protect the right of the other residents to quiet and safe enjoyment of their own homes. And it'd be just as easy to do that instead of attempting to outright outlaw religious expression. So this is one of the points where we get a good best practice for housing providers. We're going to move on from the case of the Morrises v. Hayden HOA, and we'll go from this case, which involves individuals asserting their fair housing religious rights, to something a little bit different. You may have seen in the news some developments about Epic City in Texas. Now, Epic City is so named because it's related to the East Plano Islamic Center. And the East Plano Islamic Center is a mosque located in Plano, which is a large suburb of Dallas, Texas. Now, Epic City is a planned development, community-centered project launched in 2024, and it's managed through a specially created entity called the Community Capital Partners. So Epic City is an effort by the East Plano Islamic Center to expand their capacity. Imran Chaudhary, who was previously the mosque's president of its board of directors, holds the position of executive officer and director of the Community Capital Partners business. And the proposed community, Epic City, is designed to feature over 1,000 residential units, along with a mosque, a K-12 faith-based school, a community college, and commercial shopping facilities. Epic resident scholar Yasir Kadi described the community as a, quote, Muslim neighborhood, end quote, that would remain, quote, well integrated, end quote, within the broader community. Project representatives emphasized that the development aims to create a diverse and inclusive community where people of various backgrounds can coexist harmoniously. To reserve lots in the main Epic City development, investors must purchase an $80,000 share in Community Capital Partners, which would later be credited toward a home lot purchase. None of these homes have been built quite yet. And a final crucial note is that all profits generated by the development will be received by East Plano Islamic Center. So, as you may imagine, this has caused some controversy. Now, detractors of the community have accused Epic of discriminating based on religion. It's one of its main detractors is Texas Governor Greg Abbott. But before I get into Greg Abbott's statements, we have in the Epic City situation kind of an inversion of the Morris v. Hayden case. The governing body is alleging religious discrimination on the part of a group that has not yet even begun to build, whereas in Morris v. Hayden, it was the individual or the group here that is alleging religious discrimination on the part of the governing body. So specifically, Governor Abbott has stated, to be clear, Sharia law is not allowed in Texas, nor are Sharia cities, nor are no-go zones, which this project seems to imply. Now, the governor's comments were in response to mischaracterizations of this project as a 402-acre Sharia city by commentator Amy Meck, although no public statements from the project organizers have overtly referenced implementing or creating governance structures separate from existing U.S. laws. And here, I want to make a quick editor's note. It's not within the scope of this presentation to examine the depth of Governor Abbott's implied mischaracterization of Sharia law or any other related anything related to Islam. And I'll just allow it to suffice to say that his wasn't a comment made from a rich history of scholarship, uh, and we'll move from there. Now, the residents of Plano and areas nearby to the development have expressed their own misgivings about Epic City, but those misgivings are chiefly related to infrastructure and environmental impacts rather than cultural or religious heterodoxy. So, the Governor Abbott has asked the Department of Justice as well as the Texas Workforce Commission to investigate whether Epic City is committing religious discrimination. And those two investigations have since been dropped, as we'll see, but their Epic City's not free and clear of Governor Abbott's misgivings. So this brings us to the religious exemption. And if Epic City was a development intended solely for occupation and use by Muslim residents, could its legal team then assert a religious exemption defense? To answer that, we're going to look at where the exemption comes from and a case that examines that exemption's threshold. So in 1966, excuse me, I won't start with the Judiciary Committee here. The first congressional attempt to eliminate discrimination in the sale or rental of housing occurred in 1966. There was an attempted Civil Rights Act of 1966, and Title IV of that may very well have been called the Fair Housing Act had it gone. The religious institution exemption also encompasses private clubs and fraternal organizations, and that religious institution exemption came during deliberations on CRA 66 by the House Judiciary Committee, which spent 9 executive sessions devoted primarily to revising Title IV, which is the Fair Housing section, of the proposed Civil Rights Act of 1966. And those changes were, for the most part, in areas of coverage and enforcement, and most of the changes were intended to limit the scope of Title IV, or at least they would have that effect or appear to have that effect. So, as I said, the religious exemption extends also to private and fraternal organizations. For this reason, I've decided to call it the members-only exemption here. Now, the legal logic that underpins these exemptions is found in the First Amendment, which finds necessary the right of free association and the right of privacy in order to secure the freedoms outlined in the First Amendment. And in almost all cases, those rights must come free of charge. The exemptions usually are void when they're taking place in commercial ventures. And those rights to private association and privacy can further be abridged if there is a, quote, compelling state interest, unquote. And this is something like maintaining public order. Another state interest is ensuring non-discrimination. So there exists then, by definition, some sufficient level of real or potential discrimination that overrides those exemptions and the antecedent right to free association. So we're going to look at a case that examines that threshold. And this case is called US v. Columbus Country Club. This case was first brought to the courts back in 1990. And it is so named, the Columbus Country Club is so named because it was operated by Roman Catholic fraternal organization, the Knights of Columbus. The Columbus Country Club attempted to limit occupancy of on-site seasonal dwellings to annual members only. Those on-site seasonal dwellings, hereafter and within the legal writing, referred to as bungalows, were without heating or running water, open only in the summer, and a way for members in good standing of the country club to remain near the amenities offered otherwise by the club. The club limited its membership to Roman Catholics in keeping with its founding by the Knights of Columbus. The lawsuit at issue stems from the efforts of Anita Gautieri, who was an associate member alongside her husband, who is not a Roman Catholic. She was wanting to purchase the leasehold that her mother had. Her mother inherited this leasehold on a bungalow from her deceased husband. Now, Anita Gautieri, when attempting to purchase that lease, was denied annual membership first because she was a woman. Her husband, they could have tried to override the non-membership because she's a woman if her husband had been Roman Catholic. He was not. And I've reiterated here that the Knights of Columbus are affiliated with the Roman Catholic Church. So Miss Gautieri was not having that, and so she petitioned the relevant Archdiocese of Philadelphia, and the bishop there compelled the club to change its policies, or else he would rescind the permission they had to hold Mass on their grounds, part of their association with the Catholic Church. Now, membership was available now to all genders, and they did not, however, lift the condition of Roman Catholicism for its members. Ms. Gautieri reapplied for membership in 1987 and was again denied. So, the Board of Governors of the club, when pressed in court about why they denied the Gautieris a second time, stated that the families prior demonstrated lack of ability to get along with the community. Now, of course, that's not a good enough claim to override the fair housing rights of the Gautieris, and so we need to move past it. So Ms. Gautieri filed suit after notifying the Civil Rights Division of the Department of Justice of that pattern of discrimination, and they built a lawsuit against the Columbus Country Club. So what's important here is not only the definition of, or rather, what was important to the Columbus Country Club's defense strategy was not only the definition of dwelling, but also the language. And again, here, 42 U.S. Code Section 3607A of 1988, which is otherwise known as the Religious Exemption of the Fair Housing Act. And this next slide has that written out verbatim. I'm going to be giving the slides out after this presentation, so don't feel pressured to read this all now. However, the emphasized passages, operated, supervised, or controlled by, or in conjunction with a religious organization, as well as unless membership in such religion is restricted on account of race, color, or national origin, are the really important parts here. So the district court in U.S. versus Columbus Country Club concluded, and the country club did not dispute, that it was not itself a religious organization. So then the question becomes whether it was operated, supervised, or controlled by, or in conjunction with a religious organization. And the second point of emphasis here in this paragraph, I just want to take a moment to point out, if your religion or private club discriminates based on race, color, or national origin, the exemptions are moot, you can't do it. And so that's that. So, was this a sufficiently religiously operated club to fire the religious exemption that would allow them to deny Ms. Gautieri an annual membership? So the club first attempted to deny that the bungalows were dwellings under the Fair Housing Act. They could only safely be occupied in the summer. They had neither running water nor heat. The appellate court didn't buy that. So then they moved into trying to attempt to assert their religious bona fides. Now, the club was associated with the church. They were able to hold Mass on grounds. They were beholden to the opinion of the Archdiocese, but the relationship was not found to be sufficient enough to trigger that exemption clause. And so finally, the members-only exemption, reminder, is the superordinate of the religious. Finally, the club attempted to assert its private nature. The court found that the club offered membership too freely, as long as those applicants were Roman Catholic, for it to be sufficiently private for that to apply. So what we end up with is a majority opinion that the club did not fulfill those requirements, not covered under 42 U.S.C. 3607A, and would have to allow Ms. Gautieri to apply for membership. So this brings us back to Epic City. We've seen that in order to invoke religious exemption clause of the Fair Housing Act, an organization must be operated as, by, or in conjunction with a religious organization. So in order to combat Governor Abbott's investigation, and in order to defend itself from those investigations, would Epic City be able to petition for the religious organization exemption? The short answer is no. If you want to show off how well you've been listening, you can fire that off in the Q&A as to why it's no. But the short answer is that it's a commercial project. The development would have to demonstrate its operation, again, as by or in conjunction with the East Plano Islamic Center. It cannot be a commercial venture. And Isram Qadi has stated that the community is open to secular residents. Its mosque and amenities such as a Yemeni coffee shop aren't sufficient to call it itself a religious organization. Also, it generates profits. The profits of the development going to the East Plano Islamic Center. That makes it a commercial venture. And to wrap up the story of Epic City's status today, both the Department of Justice and the Texas Workforce Commission have ceased their investigations into Epic City after assurances by community capital partners, remember the organizing entity, that it will adhere to all fair housing requirements. Whether Governor Abbott will continue in his efforts remains to be seen. And that brings us to the conclusion of some of those hairier aspects of religion and fair housing. So I hope that I've shown that religion can be a sticky problem in fair housing. There's questions like how precedent is a landlord's right to religious expression. Does that trump my marital status protections in fair housing? Does my right to religious expression trump that of my neighbors? What about my religious rights and their right to quiet enjoyment, their right to free association? Could a project that I'm trying to organize never see the light of day because of my religion and its potentially disparate impact on those affected by the project who do not align with me and my faith? So these are long court cases come to be the answers to these questions, but there are some very, very simple best practices if you are a housing professional to avoid the long court cases of finding those answers. So, as a landlord or housing professional who's interested in avoiding these problems, you should treat all applicants fairly, equal, and honestly. You should follow the same application and screening procedures for every applicant. Maintain a secular business model that keeps applicant faith separate from the transaction. Be sure about the religious status of any affiliated organizations with either your own provision of housing or that the applicant maybe belongs to. And finally, and this one always seems like a no-brainer to me, but gets lost a lot, and that's why we have a fair housing center, is to just focus on the business. If they can afford it, let them buy it. That's the relevant part of who they are in the housing transaction. And so why does all the rest come into it? So to phrase it a different way, a fair housing adherent provider will treat everyone the same, allow housing seekers to make their own choices, and make decisions based on an applicant's behavior and not their character. So that's some best practices for fair housing adherent providers. Of course, there are more of us who are not housing providers than there are housing providers. And sometimes we will run into religious discrimination, fair housing discrimination, religious or otherwise. And if you have a fair housing complaint, reach out to your local fair housing center. Here in Southwest Michigan, obviously that's us. Your fair housing center can help you draft an administrative complaint. There are federal as well as state agencies to whom to direct those complaints. There's always the right to private action, i.e. a civil lawsuit. There are some statutes of limitation that apply to these. But again, call your fair housing center and we can help you figure that out. If you are interested in further reading, the Fair Housing Act as amended, effective March 12, 1988, is the most robust last version of the Fair Housing Act. Again, some executive orders and little things that affect it. But the Fair Housing Act main course is the one amended and effective 1988. The Elliott Larson Civil Rights Act here in Michigan is a good place to gather information and further reading. And the website Justia is a very helpful resource if, like me, you're interested in reading these court cases. US v. Columbus Country Club, Morris v. Hayden Estates, the 5 that were listed earlier, NPR and KERA News, which is NPR North Texas, has done a great deal of good coverage on the Epic City development. And then finally, here in Michigan, we have the Landlord Tenant Guidebook, which outlines tenant rights and landlord responsibilities in a pretty cogent way. So that brings us to the end of this presentation. So I'll thank you again for showing up and listening to me go on about our Byzantine legal system. And I am going to leave this contact screen up for those of you who would like to copy or record that. And to the recording end, I am going to stop recording